Hello friends, hope you all are doing good by the grace of God. On today's video, I am going to discuss on a topic that is known as circumstantial evidence. Let's get started. Hope you all will like this video. Do watch the video, you will get to know everything about circumstantial evidences. So let's get started. The topic is law on circumstantial evidence. It is a trite law that prosecution must stand on or fall on its own legs, and it cannot drape any strength from the weakness of defense. However, if various links in a chain are in themselves complete, then any apparent falsity in defense or any false plea may be called into aid. Only to lend assurance to the court, one must bear in mind that before using such additional link, it must be proved that all the links in chain are complete and do not suffer from any infirmity, subject to fulfillment of the following essential. Firstly, that various links in the chain of evidence laid by the prosecution have been satisfactorily proved, and secondly, that the said circumstance point to the guilt of the accused with reasonable definiteness. Evidence can be broadly divided into two subcategories. First is direct or circumstantial, as observed in Maqbul Ahmad versus A.R. Akan, 1953. There is no difference between direct and circumstantial evidence per se. The only difference is in that as proof, the former directly establishes the commission of the offense, whereas the latter does so by placing circumstances which led to irresistible inference of guilt. Circumstantial evidence is any evidence that requires some reasoning or inference in order to prove a fact. This category of evidence may have more than one explanation or lead to more than one conclusion. In many situations, more than one piece of circumstantial evidence may be used to draw the judge or jury to a specific conclusion. The concept of circumstantial evidence has evolved through the interplay between statutes and judicial interpretation. Convictions, if based on circumstantial evidence, require an unbreakable link between the criminal and crime. The Black Law Dictionary defines circumstantial evidence as testimony not based on actual personal knowledge or observation of the fact in controversy, but of other facts from which deductions are drawn, showing indirectly the fact sought to be proved. There are popular misconceptions surrounding the validity of circumstantial evidence, as many people believe it is not as convincing as direct evidence. In reality, circumstantial evidence is an important tool used by the prosecutors to convict people. It is a common saying that men may tell lies, but circumstances do not. Nearly anything can be used as circumstantial evidence, so long as it helps create a picture of the incident or crime, leading the judge or jury to a valid conclusion. The notion that one cannot be convicted on circumstantial evidence is, of course, false. Most criminal convictions are based on circumstantial evidence, although it must be adequate to meet established standards of proof. In case of Ashok Kumar versus State of Madhya Pradesh, AIR stands for All India Report, 1989, SC stands for Supreme Court, 1890. The Supreme Court held that for circumstantial evidence to sustain conviction, the chain of events should be complete and should establish the guilt of the accused without probability of any other alternative. Further, the evidence should be and firmly established. In Sharda versus State of Maharashtra, AIR 1984, SC 1622, the Honorable Supreme Court laid down the 5 punchesal of the proof based on circumstantial evidence as extracted under. Number 1. The circumstances from which the conclusion of guilt to be drawn should be fully established. The facts so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be explainable on any other hypothesis except that the accused is guilty. The circumstances should be of a conclusive nature and tendency, pointing towards the guilt of the accused. They should exclude every possible hypothesis except the one to be proved and. Number 5. There must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show that in all human probability the act must have been done by the accused. It must be further noted that conduct of the accused as discussed under the Section 8 of the Indian Evidence Act 1872 also plays a vital role in or establishing circumstantial evidence conduct of the accused which is unnatural and abnormal, such as absconding, inability to provide explanation, inability to disclose location during the commission of offense, providing false alibis, which destroys the presumptions of innocence is relevant factors in establishing guilt and building the chain of event. As famously quoted by Sir Arthur Conan Doyle, circumstantial evidence is a very tricky thing. It may seem to point very straight to one thing, but if you shift your own point of view a little, you may find it pointing in an equally uncompromising manner to something entirely different. Pertinent citation of this topic is AIR 2019 SC 3119 Ramesh Dasu versus State of Maharashtra 2008 Clause 8 Supreme SCC 456 Benkatan versus State of Tamil Nadu AIR 1976 SC 917 Chandmal and others versus State of Rajasthan. Number 4 AIR 1936 PC0 Nazir Ahmed versus King Emperor AIR 1984 SC 1622 Sharat Sarada versus State of Maharashtra AIR 1989 SC 1890 Ashok Kumar versus State of Madhya Pradesh. And there is a famous quote at the end. Please note it. The minute you read something that you can't understand, you can almost be sure that it was drawn up by a lawyer. Hope you will get a little bit knowledge about circumstantial evidence if you have watched the video fully. If you like the video, do share and subscribe this channel. Thank you.